Always helps if I remember we've got this technology. Right. Apologies for absence. I've got David Harrison, John Michael, Leslie Bruton, and Peter Watley. Any other apologies for absence? No. Right. Declaration. Sorry. Any declarations of disclosable pecuniary interests or other disclosable interests? No. Thank you. Confirmation of previous minutes of previous meeting. Thank you kindly. Thank you for your seconding. All those who are content with the meetings, can you show or say? Thank you. Chair's announcements. I don't think I need to introduce anybody at all, so I'm going to skip over that. I've got no other apart from a warning that there's going to be a compulsory, at the moment, all-day training session at the end of October. That's at the, yes, quite, yeah, I agree, Pam. All day.
Are they going to provide lunch and drinks? Or
if it's half term, we might have grandmotherly duties.
Well, I said it will be, because I'm away the beginning of October, so it won't be then. And whether it will be all day, but at the moment that's what's planned.
But what we're being trained about.
No, the end of October it should be. So it might be then, yeah.
What's we being trained about?
I think it's to do with reasons for, basically going back to the reasons for overturning officers' recommendations on large planning. It would be, relevant, but I'm not sure an all day is best. And the trouble is, as I understand it, we're bringing in an outside expert to talk, and there won't be a chance to, if you miss it, to do it again. So I'm actually, to be honest, I imagine we'll all be quite perturbed about that situation, and there will be discussions about it. Well, quite. Yeah, and partly it's in order. Apparently, the new government legislation is going to be that all people on planning committees have to do compulsory training, as we already do within this council anyway, of course. So, but that's not yet promulgated.
Around on that day, do we get other opportunities?
Well, at the moment not, and I say this is where I'm very disturbed about that. Yeah. So yeah, I think there's going to be some quite heavy discussions about that. And Barbara, I won't be here at the beginning of October, so you'll be chairing if you're here and there's anyone. Thank you. Right, so that's it.
Chairman, can I just say that having just warned us of this event, perhaps you might want to reflect as chairman and pass our concern back to whoever's told you this, that an entire day set aside to tell us that the government wants to build 1.5 million houses and we can't refuse them anymore. That can be done in 5 minutes. It doesn't take 7 hours. And many of us work in the day, and it's going to be a one-off, so this will reduce the membership of this committee by a significant number, and maybe that's the entire that's the intention. But Chairman, I would say that without pursuing the debate here, you might want to take back the concerns that have been expressed already.
Tom, unquote, that was my intention anyway. I'm glad you confirmed my feeling on that. Thank you. Update report, we have none. Then we're on to the application, and Simon is dealing with that. Yeah.
Microphone's dead.
Oh, yours is
it's gone back on now. Here we are. Can you hear me? Good. Right. Excellent. Okay. We've got an application which is seeking to vary a couple of clauses in a pre-existing legal agreement. I'm not sure we've had one of these applications before, so I'll just briefly point out that where we get an application of this type, members have got 3 or 4 options, and I'll just tell you what those are. So, where an application is made to an authority under the legislation for modifying a legal agreement, the authority may determine A, that the planning obligation shall continue to have effect without modification. So in other words, it stays as it's worded presently. B, if the obligation no longer serves a useful purpose, that it shall be discharged. So although the applicant has applied to modify the agreement, members could, if they chose, discharge the agreement altogether. That's not what officers are recommending or what the applicant's seeking, but that's an option. Or C, if the obligation continues to serve a useful purpose, but would serve that purpose equally well if it had effect subject to the modifications specified in the application, that it shall have effect subject to those modifications. So it's option C that the applicant is seeking there to modify the agreement. The modifications are set out in the report that's before you. The current clauses are at 1.2 and 1.4 of your report, and the modifications are summarised at the at section 8 at the end. And essentially what the applicant is seeking to do is to amend the trigger points for delivering a public well, just to call it a public house, it's a bar within the partially converted 100 house, which now has a number of flats in it. And as part of that permission, it was required to deliver a bar. The trigger for delivery of that in the current legal agreement was before occupation of more than 50% of the units. That trigger point, as a matter of fact, has been passed. So there's a technical breach of the agreement as worded. Following a number of months of work by the enforcement team to endeavour to move this matter forward and resolve it, it's generated this application, which seeks to set out a seeking more time to deliver the bar, partially explained in the explained in the application, the applicant's reasoning for that, number of economic challenges, various challenges, and to seek an extended period of time with an end date by which time the original requirements of delivering the bar would need to be complied with. So let's just have a brief look at the
I
slides.
think Kathy wants to ask a question
sorry,
at
yes.
this
I want
stage.
to clarify something.
Yeah, sure.
Have I understood correctly that the bar, excuse the pun, that this has to get over is that it's no worse, the changes would be no worse than the original? Is that what you said? I can't remember the exact wording that you said that a while back, but
Equally well. So the outcome, I think, is what we're looking for, which is the delivery of the bar. No. Yeah. I mean, it's that it would have been preferable, if everything had run in accordance with the permission. You could say that in terms of any application, but unfortunately, some things don't always go to plan. What I think matters is that we get the outcome that we wanted, even if it takes a little longer. That's your officer's sort of view in a nutshell on this. So there's not many slides. We'll just go through, because of the nature of the application. This just shows where the context where the 100 house is, and just some context and some photographs. So that you can see there's the site notice. We did give it some publicity, and we wrote to the people in the flats about the proposal. that generated a number of representations. But I think you'll see the flavour of those is really focusing upon, you know, why didn't we get the bar sooner? Which is a fair point. But the application before members this evening is in a sense to try and resolve that and deliver the bar. One of the other things I need to mention to you is that we had a late representation from the conservation officer, who officers had asked to clarify in terms of the timescale sought, how long, whether it was correct that it would take 9 months drying time for the plaster to be stripped off the interior walls to let the building dry out. What had happened, just to go back a step, is that at some point in the past, gypsum plaster was used on the structure, and that's created a damp issue. So that needs to be removed before they can do the fit out of the bar. A period of time was advised, being 9 months, for that to occur. Now that period apparently commenced, according to the applicant, back in February of this year. So they're not seeking 9 months from now for that to happen. They've already sort of made some progress. But the end date, which is in section 8 of the report, gives you the sort of end period. So they've got to let the walls dry out before they can do the fitting out. So they've thought about the timescale that they need, and they've told us what that is. And officers are minded that seems reasonable. The conservation officer has observed that they could speed up that process by using dehumidifiers. I'm not sure that would shave a great amount of time off the total time scale, given that they've already sort of started that process. So we're not proposing that we say, oh well, you need less time than you've asked for. I think it would be reasonable to go with the date that's proposed, but that may be something that members wish to consider. I think that covers everything your officers have to say, other than to observe finally, Chairman, that if members were minded to refuse permission for the modification sought, I honestly don't think that's going to deliver the bar any quicker than it would if members decided to go with the officer's recommendation. It may be that my colleague from Legal Services wants to add something on that point, because there's a distinction between refusing this proposal and then what might happen next in terms of enforcing or serving an injunction in respect to the existing legal agreement. And I think there are issues with that this proposal actually to some extent resolves, that wouldn't put us in that position. But see where the discussion takes us. Thank you, Chairman.
I think we'll come and ask about the legal position a bit later when we've had a bit of discussion, if possible. Thank you. Paul, would you like to lead?
Yes, reading this other officer's report and the agenda item, one might say, what earth have we come here to discuss tonight? The answer seems fairly obvious. But what we haven't got is the full background of a lot of it. And there's a lot of information which I think members ought to be aware of when they make a decision. First of all, the dates. I was told in November 21 by a number of local people that they had already built the required number of units and sold them in order to fit the bar out before they sold them all. That was, I had not got any evidence in that beyond what I'd been told. And eventually, beginning of 22, I think we found evidence which could be used to prove that the fact that they were registered for council tax didn't necessarily mean that they bought and sold them. That didn't seem very good to me, but nevertheless, that's what we were told. But evidence arrived in 22, and we're now 2 years on with that, 3 years on with that, and nothing has happened. They did agree to start work, apparently, in 12 months ago. Nothing seems to have happened in that, although I believe a skip was delivered. Secondly, the issue of raising capital. One of the reasons, well, I would have thought that sensible developers would have made sure they got the money to complete a development before they actually started it, not expect to get so far, breach the agreement, and then decide to go out and try and get capital. That supports the local view that all this was designed to fail anyway, in order to not build the bar. Building the bar is quite important. The reason why it was there in the first place is that they put the application in without any marketing of the building as a pub, which is required normally. And this was a compromise to enable them to go ahead with improving the building without the village losing its facility, which people feel very strongly about. Pardon me. One of the reasons why they can't raise capital is because life is difficult for pubs. Well, if one takes that nationally, yes, it's quite true. But if one looks locally at the situation, it's quite different. Within the last 12 months, the pub at Shrawley has closed and then opened again to new ownership. The pub at Lynchford has new management to it, so people obviously think that works. The Red Lion at Holt has reopened and very successfully. The Crown at Martley, who had a similar agreement to this one, has now reopened after many years of closure. And the Bell at Penzax has been reopened after closure. So all the pubs roundabout have succeeded, and none have had to be closed down as a result of the COVID problem. I know they have problems because I spoke to a lot of them, but they've managed to get round that. So I think using the argument, oh, it's a difficult time for pubs, is not really a fair argument. One has to question whether it's the viability of the developers that we need to consider rather than the viability of pubs. And one factor, or the main factor that makes me say that, is if you look on their records at Companies House, you will see that 4 times in the last few years there have been compulsory wind-up petitions presented, and the first stage of advertising has gone into. They've then been withdrawn, so who knows what's going on there. But it's rather unusual for any company to have 4 winding up processes started in that time. The ownership of the company is unclear. There was someone else. Well, first of all, it was owned by a company that's gone into administration themselves, shut down. The confirmation statements being filed at Companies House still go back to 2020, when the owner who was shutting down did own the shares. And since then, it's been shown that there's been no updates. So one would normally conclude from that things are exactly the same. But the list of responsible people for the company has changed by one person. So maybe they've changed ownership. But either way, I think we need more justification than simply, oh, times are difficult for pubs, to give them further time. It's taken them, I believe, 4 years now, virtually 4 years, since they should have had it done before they sold the property. And 2 years, 2.5 years, since they definitely should have done it. And the first time I get back, in fact, an article I read which stated in 2021 that had more than half sold, which is the trigger point. So I think we need to look carefully at the reasons put forward when we consider which way to go of the three we put in front of us.
Thank you, Paul. Pam?
Well, I speak from many of the locals that have been yearning for Henry's Bar to open. Also, people who live in the apartments, certainly someone I know reasonably well, she came up from the southeast to be by her family, bought the apartment for a gymnasium and Henry's Bar so she could go and have a drink and have some social time. And of course, this hasn't happened. And as councillors, we're asked, why not? And it puts us it puts me anyway, I feel in a really tricky position. But moving on from that, I look at the two clauses which is before us to alter. And the first one is at 1.2 in the proposal. The prior to occupation of more than 50% of the dwellings, the owner shall carry out, And that is the one I think they want removed. Well, clearly, they haven't upheld that. But why should it be removed when it is actually in the application is a question in my mind. And then the other is clause 6. Oh no, this is the one they want deleted, clause 6. But what I am concerned about is that the wording here is exactly the same as the wording in 2016. Hasn't been altered. That the bar, haven't written this down very well. They should complete the construction of the public house or the buildings there. It's part of the 100 house. So it is A, ready for beneficial occupation and use, and B, has received all fit-out works. Now, a question in my mind is, that they're not being asked to have someone to run it at that stage. It's just kitting it out. And I feel I would personally like more directive on what kitting it out means, and what else did it say? All fit-out works necessary to open for trade. So in other words, they're not planning to be open for trade, which I believe is the 20th of April 2026. And on past record, I mean, Paul has been dealing with this way before it was in Baldwin Ward when I became involved in it. And it's, to my mind, you've gone round and round, haven't you, in circles trying to get this bar organised. And I know I'm wittering on. I'm sorry, I'll be quiet now. Sorry about that, Dean.
Thank you. I don't think it was wittering on, it was expressing some concerns. Simon, if you could do.
On the sort of question of having more prescriptive clauses, if members were minded to allow a modification of the clauses which are sought, I think the rationale for A and B at in the recommendation at section 8 was based principally on the fact that that's the wording in the existing clauses, and that all they're seeking to do is change the trigger from the prior to occupation of more than 50% of the dwellings to a specified date. If we were to have a more prescriptive requirement about what the fitting out works were necessary, or add something in about having somebody in to operate the pub, we'd be going beyond what we did in the original permission and legal agreement. I'd be advised by my my colleague in legal services whether it's appropriate to do that, because the there might be a question. Well, you didn't ask for that originally, albeit that they've arguably for whatever reasons reneged on that agreement. Should it be tougher than the original agreement in terms of its scope and ask? That's a question I think we want to contemplate.
That's the curveball one. I think.
How much latitude we've got there to press them further than what we previously asked for, because we're not asking for less in terms of those triggers. It's just the time. It's just the timing.
I'm afraid I don't deal with Section 106 agreements, so it's not something I can particularly advise on. I mean, it seems to me that this is a sensible resolution. As everybody has said, it's been going on for some time, and that we've actually got an end date on the horizon now. So, as I say, from that technical perspective, I can't advise. I'm afraid I'm not a planning lawyer.
Andrew.
Thank you, Chair. We're talking about an end date, and we're talking about making a judgment to actually gain what we all want, which is for this place to have a bar and be functional. It's already been in breach for 4 years. We have as an option already an end date. My question is, if we don't allow this, how can we bring it to a conclusion? I note that one of the neighbours in their responses suggested that the thing should be brought to market and somebody else at a market price actually bring the thing to a conclusion and put the bar in. Our judgment here, I suggest, is given the empirical evidence that we've got of this being in breach for 4 years, perhaps longer, is it likely that this proposed end date will be anything more than what we've experienced already? So my question on top of that is for advice on, if we vote this down, what are our options to enforce and actually get a different owner in? Thank you.
I think that's
Well,
Simon.
you recall at the beginning, I suggested that I didn't think that refusing permission would deliver the bar any quicker than if permission were granted, and that was that was to some extent informed by, I think, discussions that have been had about the enforcement process and what would be necessary in terms of I think an injunction to which might involve the people presently residing in the flats to not reside there any longer, given that the clause is worded in the agreement in a certain way. That might not be a desirable outcome if it has that consequence, which is why the revision is a more attractive proposition, because it doesn't involve that happening. We are where we are at this moment in time. Some of those flats are, well, more than 50% are occupied. That's at a consideration, I think. That may be a consequence. I don't think I'm misleading the committee to say that may be a consequence of proceeding with often that is with the enforcement matters. You have to undo what you've done to get back to the position you should be in. That's a point to bear in mind, and ultimately the expediency of taking some form of legal action would be a judgment for the head of legal services ultimately. And I think if there'd been an appetite to do that previously, that would have occurred already, given that we know we're in breach of the agreement. I don't have other details to give you about all the thought process that's gone through that, but we've gone down a certain route, which is getting this application, which sets out a timescale. You could look at it as the last opportunity, and not an unreasonable request by the applicant. Whether you agree with all the rationale that's been put forward by them for the extra time they need, it does set a clear end date, and then if after that period we don't have the bar, then obviously we can consider formal action. But we'd be at least able to say, well, we gave you an opportunity to deliver the bar. We would appear then to be reasonable in any subsequent action. If we just refuse this, we might not be in such a strong position, given we've had a request to modify it based on the applicant's circumstances. I think that's my advice to members.
Jenny, did you wish to add to that?
Not particularly. I mean, there is a lot of background to this case, and as Simon has just alluded to, an injunction has been bandied around, and it has been decided that that's not a viable course of action in this matter, and it's not for members to decide, what enforcement action is taken. As Simon said, that's if legal proceedings are to be instituted, that's a matter for the head of legal and governance.
Tom.
Chairman, thank you. I'm sure I'm not the only one who read the agenda thinking, why is this coming to the committee? It looks straightforward enough, and I was intrigued to hear what the local members may have to say. But now I'm beginning to understand it, but only beginning to understand it. Life is full of unintended consequences, and I am uncomfortable, Chair, determining this application tonight, because I would want the comfort of the head of legal services or their representative to come and explore some of the unintended consequences of whichever decision we make. Because this is a legalistic issue more than it's a planning issue. And whilst we constantly get trained for planning, we don't really get trained very often for legalistic matters. It's kind of something that is taken elsewhere. But what's clear from what Simon has said tonight, it's likely that whichever way we go, particularly if we refuse this, there may be unintended consequences that puts the council in a difficult position. I'd want to explore that further to understand the implications of voting one way or the other this evening. There are also, worth remembering, other pubs in the district. I think of the Pheasant at Welland, which is not dissimilar in these circumstances where there's housing associated with it, so long as the pub reopens. And I wouldn't want to send a message out there that actually we don't really mean it when we grant permission, and it's rather hope rather than hope over expectation. So, Chair, given that Jenny has said candidly that this isn't her bailiwick, I would personally rather defer it tonight and take it to our next meeting in 4 weeks' time, but ask for the legal services people to be here to be able to answer our questions, because I don't think there's anyone in this room who's qualified, possibly just one, to really vote one way or the other and know fully well the likely implications of that decision, because this is more a legal decision than it's a planning decision as far as I can see. And I wouldn't want to prejudice the council in any future action by determining this one way or another tonight.
Thank you very much, Chairman. What a story. I promised Councillor Chambers a drink in this bar some time ago. He's not elected of any capacity now. It's that long ago, but I'm still going to stand the drink. And if when the bar does open, whoever runs it ought to give a free round of drinks to everybody in the village. We've been waiting that long for it. It's appalling. The whole process was based on the preface that if we allow you to develop the rear ground and build all these houses, you would have the capital on hand to redevelop what's left of the bar and put it into place. This is obviously a subterfuge. It was never happened. The money was siphoned away elsewhere and spent elsewhere. And as Councillor Cummings has said, the company has had several winding up orders against it, and it was only at the last minute that the London Gazette noticed that the orders were withdrawn. So the whole thing was a subterfuge to just build houses. And we've gone along with it. And as Simon, our officer, says, we've been reasonable. Reasonable? We've been more than reasonable. It has been an absolute Mickey take all along. They've strung our officers out. They've strung our enforcement officers out. Things that they've promised were never delivered. Things got changed unilaterally, and then we had to change it again because we didn't want to go to court on it. It was a listed building of a substantial setting, and they've near enough ruined a lot of it. And here we are asking for more time. Now, I'll tell you about plastering. If this was Permerson Homes or one of the other builders, there'd be people living in it in 3 weeks. The paint wouldn't be dry, let alone the plaster. And some Mickey Mouse idea that, oh, because it's a certain type of plaster, the walls have got to breathe and all that sort of stuff. It's complete subterfuge. And if he wants to get on with it, why aren't the dehumidifiers in there now? I'm physically angry for the residents of the area. I'm physically angry for the history of the building and the sort of Mickey Mouse attitude that they've taken with our council and our officers. Just played us along. Oh no, take us to court. Sue us. We'll do it anyway. You know, from beginning to end, it's appalling. And actually, I'd quite like to vote for A. It stays as it is. Now, a Section 106 agreement, they are actually asking for basically a new one. So, okay, it's a deed of variation or a variation, and if it's negotiations, and these are contractual negotiations, the parties can enter into contractual negotiations on their equal powers and their own representation and responses. So we could vary it to our benefit too, not just his. And that should be considered. Because I can see this, and okay, nobody's got a crystal ball. A few months from now, we're back here asking for a further extension. And, oh, perhaps we'll give up and it can be turned into more houses. It is just one thing after another. So, as the councillor here said, they're using blackmail and gotten us over a barrel. But I would be minded to stick to the original agreement. If they want to vary it, well, we can vary it to our benefit too. And that should be considered. Thank you very much, Chairman.
Thank you. Any other councillor? I'm going to come in with my 2 pence worth in. And I mean, I've driven past there often and thought, and I used to enjoy going for the occasional meal there in the old days. So I've got total.
When the Llewellyns were in it, it was a marvellous restaurant.
I've total sympathy with those who are upset with the situation. On the other hand, if we do turn this down, we're left with the situation we're in, and there is virtually nothing we can do to enforce what's already there at present. It's gone past that stage, the bird has flown. So we would be left in a worse situation, I believe. I'm not sure that the proposal will give us a pub there. In fact, I'm very uncertain of that. But it's at least a concrete thing to act on. Whereas I think if we leave it as it is, then I say that basically, you might as well forget. That's not going to give us any power to enforce whatsoever. Well, that's my opinion. Sorry?
Sorry, Jim. Why make an agreement in that case? What you're saying is that we've got no power to enforce the agreement.
I don't think at this stage, it's my belief, and I'll check with Simon and with Jenny, I don't think at this stage we could enforce that Section 106 clause that's in place at the moment.
I think at the very least.
No, I think we could be advised by our officers on that. Simon. I believe that we could act in any meaningful way in the present situation.
I can't answer that definitively. Suffice to say that you know, we were a number of years on, and we've not got to that point. So to me, that suggests there's a problem with that course of action. Otherwise, we'd have got there, and we wouldn't have had this application presented to us. But I say I can't answer that definitively.
I can't answer it definitively. I haven't been involved with this for some time. I know that it was rumbling on for some time, and words like injunctions were bandied around extensively, and they were deemed not to be the most viable solution. And the enforcement officers worked closely with the developers to get this application in. Obviously, this application has come in because injunctions or any enforcement action is always a last resort. And it was seen that the bar for injunctions are particularly high. It's difficult to envisage what a judge would have done if an application was put in front of them. It certainly might not necessarily be the outcome that you would want. There's far too many variables. And hence, as I say, the enforcement officers worked hard to get this application in. And, you know, that's all I can say on it, really. I haven't looked at it for some time. And
Douglas, you want to come back?
Thank you. It's a contract. Would it not be possible to put some punitive damages in this contract if it is not adhered to this time? If we have a building contract, if I have a builder that comes and puts in my patio and I put in there, if it's not finished by the end of August, I want £3,000 off the bill. It's something that's, you know, a negotiation. Because I'm worried that without some stick behind this, we'll be back here asking for a further extension. And I would think there should be some form of punitive position if he doesn't meet that date. And at the moment, there's nothing there. You just let it run out and run off. Thank you very much, Mr. Chairman. I think I've made my point.
so it would have been useful to have these questions beforehand.
Well, there's sort of so far there's sort of two sort of get a feel. There's sort of two takeaways. One is the possibility of deferring to seek more information about the legal consequences, which was the point Councillor Wells made, and then we've had other members, Councillors Wilmot and Godwin, I think mentioned about whether the clauses could be added to, made more robust, have some consequences if they weren't met. Those are matters I think that further legal advice would be required on. So obviously there hasn't been a motion tabled to advise further, but I think it's fair to say I don't think there would be given that they seem to have indicated that they've started this process, because they talked about a total of a 14-month period starting back in February. So the end date is the 20th of April next year. A deferral of this decision, I don't think is going to necessarily delay any further the delivery of the bar than what they've indicated. Given we don't have a bar at the moment, so that's a possibility. If members feel that they need more information, then I think we need to just be clear about what information we want, because we should never be deferring really with a sort of a vague idea. We need to be precise about either it's something that officers need to go away and ask of other teams like legal services, or there needs to be an ask of the applicant, and we need to be clear about what we're asking them to do.
Paul, do you wish to propose?
I ideally would like to propose that we do not grant the change, because I think I'm not confident that in 12 months' time we won't be back here discussing it again, because so far all the agreements have been ignored, and I see no reason why, unless there are punitive damages of some sort. I see no reason why that will change from what's been happening in the last 4 years. On the other hand, I can recognise the point that Councillor Wells has made, that we don't know how it would be dealt with if we did turn it down. And I think in the circumstances, because I've been trying to find out what we would do to enforce it, and I've got absolutely nowhere. So it would be helpful, I think, for the committee to hear what our options are and what we would do, rather than us guess what we could do now. It does also come the fact that the reputation of our planning enforcement in our ward is not complimentary. There is a general opinion of a number of people that they do what they want anyway. I'm going to listen to what the council says because we won't take any action. That's even been the case when there's been appeals, which the appeals have been lost, justifying what we're doing, and we still haven't enforced it. And another case that comes to mind, that's going back some years, that goes back 8 years, I think, where we had discussed internally taking action to make someone comply with what the rules were. And we failed on getting any further on that one because the legal department turned up without the documents they needed, and contrary to what we'd agreed how we would handle it in court, so yes. So I think a definite discussion on what was open to us in terms of taking action, what we could add to the agreement to give us greater confidence that it would be actually held to this time. They've had 4 years to hold to it. It's not as if we've been at all unreasonable. And so I would propose that we defer to ask the legal department to come and tell us A, what we can do, and secondly, B, what we will do, because there could be two entirely different things. I'll get my own legal advice before then as well, so I know a bit more about that one, but it would be very helpful, I think, to do it that way. I'm not inclined to discharge it, and I'm not inclined to just change it as they want. We need a lot more than that, so that's what I propose today.
Okay. Pam, you
Yes, I'm more
second
than
it?
happy to second that.
Right. Right, in that case, I think we'll go to the vote. So the motion is to defer for further legal advice, I believe.
Okay, all those for the motion, please raise your hands. 1, 2, 3, 4, 5, 6. It's unanimous.
No.
Yes.
Well,
That's you deferred it, so
yeah.
it has to. There might be a question of when, but I think we'd try and bring that to next committee.
I was just wondering if it goes back to Paul and he's satisfied, whether it needs to come back in that case. So,
I think it has to be determined by the committee, doesn't it?
does it? Yeah.
It's true. It is true that I suppose you could. It doesn't have to come back. You could, in terms of the motion passed, you could resolve that it's the matter's delegated. But if you want it to come back, then it could come back. Yeah.
So can we amend that to delegate it to local member? Because if you're not satisfied, it will come back anyway.
But then I do think other councillors have raised specific issues about public houses in their wards, and I think they'd quite like to listen to what the legal situation is with this. Well, I don't know. That's what I think.
It's the generality of enforcing Section 106.
Exactly.
That's more a training session, I think. Yeah, as long as it's not an all-day training compulsory session. No, we've actually voted on it, so this is a bit late to actually do that. We did, yeah. So, so actually it's vote for deferral and that's it. So I don't think we can take it further on too late to have to. So,
Yes, we've
So-
got to allow a member of the legal department to attend and tell us what tell members what we could do in terms of options of sort of
And the
and and what we can do, the consequences, and what we could add to the agreement to encourage compliance.
yeah, I think that's the important thing, to be honest.
I suggest we allow them, we request them to attend.
Yeah, well, yes,
I
regret,
think they will. I think yes. Right.
Well, if they couldn't, I'm sure they'd be able to furnish us with the information and officers could impart it. But you may want to ask them questions. So
Right, Daniel wants to get it off running, so I'm going to close the meeting. Too late for you to go running, Daniel. Oh, what a shame.